Hey everybody, good morning. I'm JD Houvener and welcome to the Bold Today show. You made it. We're here every week, every Friday, every Wednesday. We just moved to Wednesdays at 9 a.m. Pacific and noon on the East Coast. I'm excited to have you here today. We're welcoming a friend and colleague I've known for a number of years, Carmine Denisco. He's a venture guru. He's one of my mentors. We talk. We've been doing a podcast for years, and it's a pleasure to have him on. We were just talking before this show. So he is kind of an expert on design and manufacturing. So bring your questions on that. Later on, we'll be doing the Alvo.com. So if you're tuning in, listening to this and you're at Alvo.com, question asker, just hang in there. You can fast forward if you really want to about the last half of the show. We'll have that for you. But I may just let you know, if you're first time watching this on our platforms, give us a like and share this with your folks on social media. We're trying to get a nice community of inventors, entrepreneurs asking questions of me. I'm a patent attorney, owner here at Bold Patents Law Firm, and happy to talk with you about anything you want patent related. I do have a disclaimer I'll be putting up here. Do not share inventions here in this forum. This is a public forum, so it's not confidential. If you do have an invention, you want to get some legal advice, please do get with us and shoot me an email. I'll give you my email address here in the comments later to follow up. All right. So without further ado, I want to bring on Carmine to the program here. Carmine, welcome.
What's happening, guys? How you doing?
Good seeing you. Good seeing you. We're doing this program. This is it's a Facebook Live, YouTube Live stream, relatively new. We get 4 or 5 viewers come on, and so as we kind of go through, we'll try to prioritize live questions. But I think you and I should just chat, because I think a lot of this material, it gets me excited. I know we were talking before. This is what we're passionate about, and I think we'll probably always be talking about this. And there'll be a ton to work on. And you mentioned that you had just gone to yesterday sort of a panel with the PTAB, the Patent Trial and Appeal Board folks. And you're involved in lots of different things here. Do you want to share a little bit about that program a little bit?
Yeah. So as you said, man, we never don't have anything to talk about, especially the inventor biz, the inventor world. I mean, both of us kind of share the same passion of helping inventors, product developers, getting things done, getting things the right way. One of the things I'm involved in, I'm a board member for the United Inventors Association. Join, all you listeners out there, join the UIA. It's free, so you might as well join. And it's a great place for resources, just like the resources JD supplies, UIAUSA.org. So as part of UIA, we interview and talk to a lot of different organizations in order to get information and help inventors when they do reach out. And the PTAB is a big thing, not for us low-level inventors like me who have 1 or 2 patents, but people that have some big products, they go after it. And the PTAB, which is the Patent Trial and Appeals Board, and it's when they're having an issue with a patent, or someone is trying to invalidate a patent, maybe a big company or inventor, and you could probably talk to that even better. So we were able to reach out to the actual team, and there were about 5 of the representatives from the USPTO there, and these guys were so knowledgeable. Being an inventor, but not a patent attorney, I was kind of lost, but we had some people on there that knew what the heck they were talking about, and it was a lot of fun. They really are looking out for inventors, but sometimes it gets a little misconstrued that hey, they're taking away my patent, or I got to go to trial.
Yeah, so these were actually the judges, or these are the administrative folks that make the decisions on PTAB rulings?
Yeah, so there was no judges there, but these are the administrative people, the people that I guess that choose the judges, the people that look over the paperwork, I guess they get the laws, and you probably know this better. They get their marching orders kind of from Congress, in a way, and they kind of like us have their hands tied. They were trying to answer our questions as good as possible, but when you get the government and laws things involved, it's kind of hard to draw that umbrella-like answer.
Right. And so for some of those that may not know, so the Patent Trial and Appeal Board, I mean, this is the one instance that's kind of in the news is, after you go through the process of inventing, doing a patent search, filing an application, going through the prosecution, back and forth with the examiner, and finally get to the finish line of having your patent be granted, Now you've got to go enforce your patent rights. And so instead of someone, just sort of, paying you for your patent rights or saying, oh my gosh, I'm sorry, they say, no, I'm going to take you to the PTAB and try to invalidate your patent. And so that they're at a secondary tribunal. It's a court, honestly, basically an efficient court that will hear patent cases only for those that are saying, look, for someone that may be infringing, that is alleging that your patent rights, the claims are not valid. And so that's one of the main reasons why I would think you're asking these questions. A lot of inventors like, look, this is an invention. The USPTO stamped it and said this is a granted issued patent. How on earth are you able to invalidate that post grant? And it happens, a lot of cases with these computer implemented inventions. This has been going on for five or more years. So what were some of the questions you were asking? The panel. What were kind of some of the big takeaways?
Because the UIA and a lot of people that were on, we had several people on, were really representing inventors that, and a lot of inventors, we don't have these really deep pockets. And we were wondering, how the heck can we go up against these really multi-billion-dollar companies when they're trying to invalidate one of our patents? All we want to do is sell products, and these companies are saying, hey, come, we're going to take you to we're talking about a serious court case, that could cost in the millions. And we were asking, how we can protect ourselves. What should we do? What should we do prior? And a lot of the people that representatives from the PTAB were really speaking about during the patenting process, JD, and something that you guys do. I know you guys really prepare, get as much prior art as possible, make sure all your I's and T's are crossed. Really the preparation prior to getting the patent is very, very important. And that's what they were talking about, as you probably run into.
Yeah, well, I mean, that's exactly. I mean, so we don't do litigation, it's litigation to us is basically going into federal court, right? Federal court or ITC. And so what we do is, we do help with folks at the PTAB. And that is sort of a mini litigation, and that can feel just like a litigation because you're having to go through, have obviously hearings and dates that must be met, just like a litigation and discovery. So it's sort of like a compact version of litigation. I think the initial concept was to sort of reduce cost, right? And so I'd be curious, I don't practice that a whole lot, but we do support litigators in PTAB processes. But most of our efforts are on getting a solid patent that is founded in, that there's no real worry about the scope of rights, that we're not worried about having prior art come up later. That's why we are huge advocates of doing solid patentability searches. We've searched high and low to have the best patent searchers in the world work for our clients, and our attorneys look at those results, analyze them, and see if there are any holes in it. So that the clients know what they're getting into when we file, because those are the reasons why, how you can invalidate a patent after the fact. It's true that examiners are human, and I think that's the concept that, hey, the examiner maybe missed something, or maybe something wasn't quite disclosed and it should have been or could have been. And so it's if you can get it right, if you can get the prosecution right, which is getting the patent granted in the right way, it should eliminate these costs and the burden on inventors and rights holders in future litigations. So very interesting stuff. Yeah.
Yeah.
Let's see. No doubt. Yeah, for sure. I wanted to also chat with you a little bit about kind of what you're up to. I know a lot of this is fresh, but Inventors Launchpad, and that's what we're on your podcast there in 2018, 2019. If anybody out there wants to go look at the archives, that's good stuff. It's the Go Big, Go Bold on Inventors Launchpad. I'll put the link there. Tell me what you guys are up to at Inventors Launchpad.
Yeah, so at Inventors Launchpad, as usual, we are helping all types of inventors in all different phases. And, we're going through a refresh. This pandemic, like with a lot of people, have really made us stop and think, how do we really want to help not only community, but bring our company up to standards and things like that. And we're starting a secondary company called Earmark Sourcing, where we can just concentrate just on manufacturing and sourcing products, because, when you're developing products and you're developing inventions and prototypes for clients and you're speaking with them, it takes up a lot of time. There's no doubt about it. So we're trying to really break off where we can just concentrate on that manufacturing process so that when we get that product, we got that design, we get that prototype, we say, okay, we're ready to manufacture, we could throw it over the fence to a company that just specializes in the manufacturing step. And it's really helping us. We got about 30 products that we're making, that we're developing and manufacturing in 7 different countries right now. We have about 40 projects at the Inventors Launchpad side. That's why I have no hair on my head. It's just insane, but it is so much fun. And we get products from all over the place. You know, during the pandemic, and you've probably run into this too, JD, that people were really thinking about ideas and how they can make things better, and you know, add-ons and kitchen products and house products and, you know, health products. We got health products, so many of them, you know, and it's been crazy. It's been so much fun that you got to stop and go, oh my God, what are we going to do? So it's been nuts, and we love it here.
Good. Yeah, we've got a lot of PPE inventions this year. Incredible. I mean, the outpouring of different types of masks and hands-free and, you know, wild stuff, you know, and we're having to do conflict checks. It's been a really burden for us because we can't obviously take on the same invention. So I've had to call ethics attorneys and say, this is pretty similar, and like, oh my gosh, because people are just inventing a lot of the same things. It's just because it's what's the problem right now. So people are solving problems, what we do. And what an honor to be part of that solution process. So, so that was earmark sourcing. Is that right? That's what you're working on, and that's manufacturing and little design as well. Is that what you said?
You know, every product, and as you know, even when I say it's ready to manufacture, when I get it to the factory, there's going to be some design pieces. There's going to be some components where the factory says, hey, we might have to spin this around. We might have to make this a little shorter so we can eject it out of the mold. Or, hey, we can save 4 inches on the packaging and you got better shelf space for the retailer if we do this. So I want everyone out there to listen. You know, when you say, hey, my product's ready for manufacturing, it's not really ready for manufacturing, but that's okay. You're going to that next step. When a manufacturer looks at your product, they might make suggestions. You don't have to listen to them. But if they make some suggestions, it's usually in the better.
Got it. So you probably got, you know, a pretty good Rolodex you've been developing on designers, right? Folks that are working with inventors that, you know, they've got this design that they've kind of honed in on. Now they're ready to go mass manufacturing, or they're ready to, you know, to pull the plug. Does that sound about right?
Yeah, cool. And that's kind of why we kind of separated a couple companies, because we'd have somebody who using an engineer, using a designer, say, not even in this country, they could be anywhere or in this country, and then they send us the files, and we don't have to go through Inventors Launchpad, because Inventors Launchpad is more of, for that beginning inventor, that person who needs to go through all the steps. But if you're ready to manufacture, you can go directly to earmark sourcing. We can talk to our manufacturers, talk to our factories, and get you going a lot quicker.
That's awesome.
So it really helps in that sense, because, you know, you don't want that roadblock. An invention needs to get going. You know, an invention takes a long time. You know, as you know, JD, you can get started. It could be a year before your product's done. Everybody wants it done in a month, 2 months.
Oh, yeah.
It takes time.
Absolutely. You know, and when I'm always thinking about my, you know, clients, and, you know, a lot of our clients are those solo inventors, and they're out there and they're scratching their heads, and they're at the beginning stages. Would it ever make sense for them to, you know, to kind of get a full picture on their costs and what their investment might be, to talk with you early on in the process? And could you help them kind of get an idea as far as what costs look like, how far along they need to be to get to manufacturing, you know, what the risks are, all that?
Yeah, I would say to any inventor, even if you have an idea, just thinking about it, sketch on a piece of paper, you know, get a team together, talk to me. It doesn't have to be just me. There's plenty of guys out there that are good. Talk to me, talk to somebody like JD. You don't have to be locked in. You don't have to say, oh my God, it's going to cost me so much. But get some information first before you not only go off in the wrong step in a sequence, because that sequence, if you follow the right sequence, you can move along a lot faster. As soon as you take the wrong or misstep, it could use up your resources. And, you know, as you know, JD, resources just aren't money. Us inventors, I could be in the garage every night working on my invention. That's a resource. My time is a resource. And you don't want to be working and using up those resources in the wrong direction. So it's good to get a team together. It's good to talk to people that are doing it. I mean, I've taken thousands of products to market. Don't talk to your neighbor. Don't say, oh, what should I do next? Your neighbor's probably a great guy, but if he hasn't taken a product to market, you may not want to listen to him.
That's right. Carmine, how do people get a hold of you? What's the best way?
Yeah, so best way is probably through social media, or you can email me, Carmine at Inventors Launchpad, or Carmine at Earmark Sourcing. Now I have 2 email addresses that I got to follow, but a lot of people just reach out to me on social media. send me a quick note, and then I can direct them to their best place. Obviously, anybody that's talking to me, I send them over to JD too. You definitely want to, before you start spending any money beginning, you definitely want to get a hold of somebody like JD and make sure that your product is even patentable, sellable. You want to make sure you're going in the right direction.
Thank you, Carmine. I'm going to put you backstage. We had a few viewers on. If anybody has any questions, I'm not seeing any live questions yet. Fire them away. I know there's a couple minutes of a delay as well. So, Carmine, thank you for being on. I'll bring you back on if there were any questions at the end of the show. We're going to go to our alvo.com questions. So, thanks, Carmine.
Cool, man. Thank you. Talk to you soon.
All right. Excellent. So let's jump to our Alvo program. Alvo is a platform where I volunteer as a patent attorney to answer questions, anonymous questions that come in from around the country. And so what I'll do is I'll share my screen here with you guys to take part in this with me. All right, we'll jump to that right here. Hopefully we're able to see that. This week, we just have one patent question, believe it or not, no patent infringement, and then 8 trademark questions. So I'll do my best to blast through a few of those trademark questions. I may not get to them all. This one comes out of Las Vegas, Nevada. And just a quick disclaimer, I haven't read these before. So some of these questions can be obscene. I've seen a few of them. Hopefully these aren't. So is a patent pending different than a patent? How? What does it mean that you can patent an idea and not a process? Thanks. Interesting. So I would say for sure, I'd love to answer this first question, which is what's the difference between a patent pending and a patent? This is all about understanding that a patent itself, a patent is granted, means it's already been examined by a USPTO patent examiner, and it has been issued, meaning the inventor or the owner of that patent has the right to exclude anyone in the country to make, use, sell, or import the claims that are on that patent. Patent pending means that it has been just filed. Simply a provisional patent application that has been now filed does mean that you're patent pending. So it doesn't necessarily mean that there's been any examination done. Certainly doesn't mean that there's been any approval or granting of rights. So there's no rights granted for patent pending. But it does mean that you have first in time, meaning if there was another inventor with the same invention that files after you have filed your patent pending, you will win in a priority battle, and you'll have the rights before they do. So it's all about who's the first inventor to file now, not who is the first to invent it, interestingly enough. So the second question here, what does it mean that you can patent an idea and not a process? I'm not quite sure where you're getting that. I mean, what I will say, though, is that you cannot patent an idea alone. And I actually talk about that a lot in my book, Bold Ideas, The Inventor's Guide to Patents. Is an idea is sort of this, it's wonderful. Okay, it's a wonderful thing, and a lot of people have ideas. It's the ability for you to be able to put that in words or writing, such that you or someone like you could go out and make it. Right? That's where you become. That's where you're at in an invention. You're at the point to where you're actually able to describe it and enable your invention to that amount of detail. So if it's still conceptual, you're still kind of mulling it over. Right, that's great, and you can start moving forward. And we've worked with a lot of clients of ours that have been in this idea phase, and we help them with a thorough patentability search to help them kind of flesh it out and understand how and where their invention is unique and where they might find themselves in the marketplace. Okay, hope that answers your question. Thank you for that. Let me jump to our Alvo trademark questions here. I don't see any live questions, but please do fire those away. I will take a priority on those if they come in. Let's jump in. We've got a few more minutes. Like I said, I may not be able to get to all 8 of these. Let's jump to the trademark application questions. Okay, so this one comes out of Seattle. I kind of like this, right? It's local. How do I go about wording a copyright to make shirts? I'm currently trying to start a clothing brand, and I want to know how to get the wording copyrighted for shirts. Fascinating. Okay, so one thing to understand about shirts, and this is a classic misconception, is that with shirts or any articles of clothing, if you're trying to start a clothing brand, which a lot of people, it's fairly popular to try to do that. What's actually important about the trademark, okay, the actual brand, isn't what's on the shirt. It's actually on the tag, right? The brand is about who manufactures that shirt. What's the source of those goods? So that's what's key, is making sure you have that logo or that word mark brand of who the manufacturer is on the tag of the shirt, identifying where the article came from. Now the artwork that goes on the shirt, that is, as this question asker may be correct, it is under the copyright domain, because that's copyrights govern and control rights about artistic works, from written works to music, right, performing arts, all that is protectable under copyright. And so to get a copyright registered, it's not through the USPTO at all. It's through a separate office called the Library of Congress and through the Copyright Office. And so you can get registration for unique works that are from your own mind, meaning from your own creation. You're not using them as not coming from a derivative of another's works. We actually at our firm don't practice copyright prosecution. It is often something that can be done on your own. So there's plenty of written articles on the copyright website. I encourage you to go look at that. And it's simply a matter of documenting who you are, when you created it, and what the artwork is. There's no requirement for it to be technically novel or unique. Okay, you just got to be able to declare and make an oath that it came from your own work, and that it's not necessarily something you've made a derivative of something in the past that belongs to someone else. All right, let's jump back and see if we have any questions from our live audience. I don't see any right yet, so I'll jump back to our questions here with the trademark piece. Okay, so this one is coming out of New Jersey, Jersey City. How do I reactivate a dead trademark? In 2017, I had registered for a trademark. However, due to business and perhaps business issues with finances, I let the trademark expire. How do I activate the same trademark again now? Well, because it has expired, you'll actually have to, in a sense, reapply. Okay, because you've now got to prove that you, when you started picking up that brand, again, that mark or that whatever the word mark or the logo, and at what point in time you started to sell, whether it's 2020 or 2019, that's the date where the priority would come into play. The issue that they're looking for will be if any other competitor or someone else in the same class, right, the same type of goods or services, has been selling in that gap, right, between 2017 and let's say 2019, when you started up again. If someone else had started using that mark that was dead, they will actually have the priority to that. And so they'll need to, the trademark examiner will look to see if there was a prior use in that sort of a gap after you had to let it go abandoned and then become expired. So it'll be a full reapplication. Certainly having that history will help in essence to show that earlier priority date, but that gap is what the examiner will be looking at, and you'll need to prove that you're using a specimen in the same class. All right, we'll probably do one more question here on the trademark side, and then we'll answer one on the patent infringement side. Looks like we just got one come in. So this is out of Buffalo, New York, trademark application question. Can I trademark a name that's already used in the related field, but a clearly different subfield? Let's say I want to trademark my company XYZ Lighting, and we sell stage lighting products and related systems. There's no other company named XYZ Lighting, but there is a line of lighting products called XYZ, and that name has been trademarked simply as XYZ by a company called ABC. Oh my gosh. That company, however, sells fixtures and chandeliers for homes and businesses. So although very different, my products and their products are related field. So basically, is there a conflict? And they go on to ask more about this. The key is to obviously going to go look at what the registration is for XYZ. Okay, you say they're in lighting products. Okay, lighting products, not necessarily stage lighting products, which is what I believe you're going for with XYZ Lighting. So the first problem in essence could be, hey, if they're currently selling lighting products, but the registration covers a much broader category of stage and performance, and which might also cover stage lighting products, that could obviously be a concern, and it would be confusingly similar just based on your example here. So that would probably be enough to have a trademark examiner reject your application just because it's so similar. The second problem is you're trying to distinguish your mark by using the word lighting. Because what you're selling is actually lighting, it's merely descriptive. And so even if there was no other company that had a registration for XYZ, your use of the word lighting will have to be disclaimed anyway. You won't be able to get rights for the word lighting because it just describes what you're selling. Now, if you were XYZ lighting, but you're selling hamburgers, both of those would be descriptive. I mean, not to say I don't think it's a very good trademark, but XYZ lighting would not be descriptive of hamburgers. So you could be able to use all those words in that mark. There's a lot packed into this question. I hope that was helps kind of shed some light to that. I want to jump to the last patent question for the day. It looks like that one actually just got closed out. It was miscategorized. So that's the end of the classic program. I want to bring Carmine back on for the last few minutes. How you doing, Carmine? Welcome back.
I'm doing good, man. That's a great program where you can get those questions from all over the place. Yeah,
it's excellent. I'm a big advocate. Alvo.com. I've been involved in that for years, and I like it. I feel so what I do is I actually will record this, as we are right now, and I'll send a link out to the post production link right to that answer. Say, hey, look, I answered your question on the live, Facebook or YouTube video. Here's your answer from me personally. As I kind of go through it. So it's a fun way to give a good answer. Nice long complete answer while making getting a little more folks here hopefully on this program to build this out.
Yeah, that's cool. That's really cool.
Yeah. Well, I'm glad to have you on. It was a pleasure seeing you. I think we're going to be chatting again soon. I think we'll get some synergy here as we kind of get through this year and into next year, make some plans. Like I said, I didn't have any live questions for us today, but we're just starting this new platform on Wednesdays. So thank you for those that were reviewing, and thanks again, Carmine, for tuning in to the Bold Today show. Have a good day, everybody. Go big, go bold.
Bye, everybody.